This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're continuing the Claims Commandments with Claims Commandment number 4, Thou shalt understand the policy. In this, the fourth of 15 Claims Commandments, we deal with the need for every insurance claims professional to read and understand the terms and conditions of the policy that made promises to an insured who is presenting a claim. Insurance policies are contracts. To understand insurance claims, the adjuster must understand how all contracts, and specifically insurance contracts, are interpreted. Rules of contract interpretation have developed over the last 300 years and are applied by courts with the intent to fulfill the desires of all parties to the contract. People and judges who are not conversant in insurance and the interpretation of insurance contracts believe the insurance policy is difficult to read and understand. They're wrong. However, as one court said in a case called Delancy versus Rockingham Farmers Mutual in 1873, the New Hampshire Supreme Court concluded, quote, "This policy, if read by an ordinary man, would be an inexplicable riddle, a mere flood of darkness and confusion. Should some extremely eccentric person attempt to examine the involved and intricate net in which he was to be entangled, he would find that it is printed in such small type and in lines so long and crowded as to make the perusal of the document physically difficult, painful, and possibly injurious." Close quote. Since 1873, insurance policies are printed in large print and in language by statute that anyone with a fourth-grade education can understand. Still, there seems to be regularly disputes taken to court about the meaning of terms, conditions, and limitations of the policy of insurance. The following rules govern the construction of contracts of insurance. 1. If the terms of a promise are in any respect ambiguous or uncertain, it must be interpreted in the sense in which the promisor believed at the time of making it that the promisee understood it. 2. If a written contract is so worded that it can be given a definite or certain legal meaning, then it is not ambiguous. However, if the language of a policy or contract is subject to 2 or more reasonable interpretations, it is ambiguous. 3. When a policy is interpreted, the provisions of an endorsement control the interpretation over the body or declarations of a policy when the two are in conflict. For example, if the language written to limit an insurer's liability to the appraised value appears on the declarations page, while the valuation condition that provides for an actual cash value adjustment appears on a form endorsed to the contract, the endorsement's language would control the interpretation of the contradictory language of the policy. However, the fact that the 2 sentences could have been written more clearly did not mean that they were ambiguous. Consider the reasonable expectations of the insured when doing so include the understanding that every insurer is presumed to be acquainted with the practice of the trade that the insurer insures. For example, more than 150 years ago, the U.S. Supreme Court in Hazards Administrator versus New England Marine, a 1834 decision of the U.S. Supreme Court, adopted the rule. The Supreme Court concluded that no injustice is done if insurers are presumed to know their insured's industry because it is part of their ordinary business. In McKinnon versus Truck Insurance Exchange, a 2003 decision of the California Supreme Court, the California Supreme Court stated the primacy of the reasonable expectations test when interpreting insurance policies. It decided that the reasonable expectations of the insured required coverage to exist for an ordinary act of negligence, even if it involved pollutants. Where the language of the policy is clear, the language must be read accordingly, and where it is not, it must be read in the sense that satisfies the hypothetical insured's objectively reasonable expectations. Therefore, if you as a claims professional find the term is clear and unambiguous, there'll be no need to apply the reasonable expectations test. If you find any ambiguity or determine the insured should be paid, the application of the reasonable expectations test will give a court the ability to construe the policy against the insurer and in favor of payment of the insured's claim. Most states apply the plain meaning test. Long-established insurance law supports the conclusion that insurers are presumed to know and be bound by the meaning of the terms used and customs adopted in their insured's industries. Insurers and insurance claims professionals faced with a need to understand and apply the wording of a policy of insurance must now conduct their investigation to include 1. A detailed investigation of the facts of the loss and policy acquisition. 2. A determination of the expectations of the insured and the insurer at the time the policy was acquired. 3. A determination of the purposes for which the policy was acquired. And 4. An examination of all communications between the insurer and the insured or their representatives. To conclude a thorough investigation, the insurer must at least conduct a detailed interview of the insured, the claimants, the brokers, and the underwriters. When there is a dispute over the meaning of common terms, the court will often find it necessary to inform upon the understanding of persons in the particular business insured, so that the judge must consult the opinions of experts. Expert testimony can be helpful in establishing that the insured's or the insurer's interpretation of the term at issue is difficult or different from that advanced by the other that was reasonable. In California, this may be sufficient for a party to prevail because although insureds are treated differently, so that even if the insurer's interpretation is considered reasonable, it would still not prevail, for in order to do so, it would have to establish that its interpretation is the only reasonable one. An insurance claims professional can never make or recommend a decision with regard to an insurance claim until he or she has read the entire policy as it relates to a loss, interpret the policy wording in accordance with the rules of interpretation I have stated above, and conduct a complete and thorough investigation to determine the reasonable expectations of the insured, and if unable to decide, to seek the advice of competent coverage counsel. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the link zalma.com/blog, and you can subscribe to the blog so that you receive an email every day it is published, which is usually at least 5 days a week. You can also subscribe to the videos at rumble.com and youtube.com, and I would appreciate it if you click on the link on YouTube to like the blog post, and you click on the Rumble button at rumble.com. And if you found this video and the blog posting to be of interest and useful to you, And your colleagues, please advise your colleagues it exists and tell them that they might want to view and subscribe to the blog as well as to the videos. Thank you for your attention.